Imagine this. You come up with a brilliant, innovative product, and then you see exact copies of it popping up in major department stores. So you take the copycats to court, you win big, and then somehow you lose it all. Today, we're going to get into the strange and really cautionary tale of a company called Pearl Dean and a legal battle that took a turn nobody saw coming.
So, look at this number. Over 20 million pesos. That's the huge amount that Pearl Dean was initially awarded by a court. I mean, it looked like a total slam dunk. A clear-cut case of infringement, and a big win for the little guy, for the original creator. The evidence seemed airtight, and it looked like justice was served.
And that is the central mystery here. How does a 20 million peso victory just poof, vanish into thin air? How does a company that seems to have all the right legal documents walk away with absolutely zero? Okay, let's dive in and unpack this.
To really get what went wrong, we've got to go back to the beginning. We have to understand the product at the heart of this whole fight. And it all starts back in the 1980s with a very, very bright idea.
So, Pearl Dean developed these super eye-catching advertising displays. Basically they were backlit boxes that made posters just glow. They were sleek, they were modern, perfect for the new shopping malls popping up everywhere. And they marketed these cool new things under the brand name poster ads. Okay, so this timeline is absolutely key. It all kicks off in '81 when they get their copyright. By '85, they're on the brink of this massive deal with Shoemart, SM. But then, a year later, SM just suddenly pulls out. Kind of weird, right? Things go quiet for a few years, and then bam, 1989, Pearl Dean discovers that SM stores are filled with identical lightboxes built by other companies. And get this, one of them used to be their own manufacturer. On the surface, it looks like a classic case of a big company just stealing a small company's idea.
So of course, Pearl Dean sued, and at first, it looked like they were going to win big time. The courts were totally on their side. Let's look at what happened when this seemingly open and shut case actually went to trial.
The first court, the regional trial court, came down hard on Shoemart. It found them liable for both copyright and trademark infringement. It awarded Pearl Dean over 16 million pesos in lost profits, plus millions more in other damages and fees. It was a total victory. Case closed, right?
Nope. This is where the story just takes a wild turn. Shoemart appealed the decision, and the Court of Appeals didn't just, lower the fine, it reversed the entire decision. That 20 million pesos? Gone. The victory? Wiped out. Pearl Dean was left with absolutely nothing.
And this is the part that makes you scratch your head. They had the paperwork. They had a copyright certificate for their advertising display units and a trademark registration for poster ads. So how on earth could they still lose? Well, it turns out they had brought completely the wrong legal tools to the fight. Okay, so the first reason this whole case just fell apart comes down to a really common but absolutely critical misunderstanding of what a copyright actually protects. This was mistake number one.
So let's be clear, a copyright protects the expression of an idea. Think of a book, a song, a painting, or in this case, a technical drawing. It protects the specific way an idea is written down or drawn out. It does not protect the underlying idea or the system itself.
An invention, on the other hand, is protected by a patent. A patent protects the actual functional thing, the machine, the new gizmo, the chemical process. It's the right that stops other people from making, using, or selling your invention. See the difference?
Now this is brilliant. The court itself gave a perfect analogy to explain the difference. A copyright protects a cookbook, the words, the photos, the layout, but it does not give you an exclusive right to actually bake the cake using that recipe. A copyright protects the architectural blueprints, but it doesn't stop someone else from building the actual house. And here's the kicker. Pearl Dean had a copyright for their technical drawings, but what they really needed was a patent for the physical lightbox.
And that, right there, was the fatal flaw. The court basically said, since Pearl Dean never patented their lightbox invention, they had no legal leg to stand on to stop anyone else from building it. Their copyright only stopped people from photocopying and selling their drawings, which, of course, isn't what Shoemart did. They just built the things shown in the drawings.
But wait, you're probably thinking, what about their trademark poster ads? Surely that gave them some kind of protection, right? Well, that leads us to the second fatal error in their case.
Okay, this part is almost unbelievable. When Pearl Dean registered their trademark poster ads,
The certificate they got specified it was for use on stationaries. We're talking letterheads, envelopes, calling cards. But where were they actually using the name? On their illuminated light boxes, a totally different category of goods.
And the law on this is brutally strict. Your trademark protection is explicitly limited to the specific goods or services that you list in your registration. Since light boxes weren't on their list, their trademark registration was, for this fight, completely useless.
And to make matters even worse, the name itself was just weak. And you don't have to take my word for it. Get this. This quote is a direct admission from Pearl and Dean's own expert witness during the trial. Even their guy had to admit the name was so generic, it was hard to link it to any one company.
Now, there's this legal concept called secondary meaning. It's when a generic-sounding term, like, say, Apple for computers, becomes so famous and tied to one company that it gains protection. But the court found that poster ads, which is just a simple contraction of poster advertising, never ever got to that status. It was just a descriptive phrase that anyone in the ad business could use.
So after this huge legal battle, this roller coaster of court decisions, what's the ultimate lesson here? Well, it really all boils down to one simple idea: using the right tool for the job.
You gotta think of intellectual property like a toolkit, right? Each tool has a very specific purpose. A copyright, that's your hammer for artistic expression. A patent, that's your wrench for a functional invention. And a trademark, that's for protecting your brand identity on a very specific product. You have to know which tool to pull out.
The real tragedy of the Pearl and Dean story is that they had a genuinely cool, innovative product. Their failure wasn't a failure of invention, it was a failure of legal strategy. They copyrighted what they should have patented, and they got a trademark for the wrong stuff. It's like they showed up to a sword fight holding a shield made of paper.
And that leaves all of us with a final and really crucial question to think about. Whether you're an inventor, an artist, an entrepreneur, whatever you do, your ideas are valuable. But as this 20 million peso case proves, just having the idea isn't enough. You have to ask yourself, are you absolutely sure you're using the right tools to protect it?